Okay. Well, you didn't show up for the hearing. That's not her fault.
And
We
I
had a
paid
hearing.
someone that day. I paid someone that day, and they didn't make it to come and get me, and I walked home.
And the insurance is in your name, and now you're outraged. It's your own fault.
Yeah, this is why our country works great. Because Cindy's using my car. I said that.
And he just doesn't understand, and he'll be mad no matter what.
Had an interesting and very confusing case today. Multiple stories, mixed emotions, and a courtroom that feels more like a group project gone wrong. The judge's face says it all, confusion and disbelief. The plaintiff's trying to piece everything together like a mystery novel, and somehow the only person not confused is the defendant, which is the real problem here. He genuinely thinks saying, "I'm not at fault," is enough to make a judge go, "You know what, fair point." Spoiler, that's not how any of this works. He's about to learn the hard way how the system actually operates, and why you should always insure your vehicle before handing it off to anyone, because in court, ignorance isn't innocence. Let's go ahead and dive in.
Good morning. Good afternoon, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
And Mr. Bradley Roberts is here by telephone only.
Yes, sir.
All right. This is a claim by Liberty Mutual Personal Insurance Company versus Bradley Roberts. And this has had a bumpy ride. We've had a couple of previous hearings on this. We had a hearing on March. Let me go back even all the way to the beginning. We had a hearing on December 16th. Mr. Roberts appeared. He admitted there was no insurance on the vehicle at the time, and it was screwy facts. The vehicle was allegedly owned by Cindy Vandigrift. It was insured as Jessica Adams, and the driven vehicle was driven by her son or nephew, Xavier Adams. Anyway, there was an accident, and no police report was filed, and so all these facts were raised, and so they just continued the matter for 90 days for additional discovery. Mr. Roberts didn't show up. We discontinued the matter to March 31st, 2025. And Mr. Thomas Duquette was here. So we adjourned the matter for 90 days for discovery, and the defendant never complied with any of the discovery. So he didn't answer any of the plaintiff's requests for discovery, and he didn't show up for the court hearing. So Mr. Duquette moved for a default judgment, $10,415 in costs. In damages, $232.13 in costs, and a $75 attorney fee. So a judgment entered by default on March 31st.
Which should have never happened. You heard me say she jumped in it and started it and put it in reverse. She took control of the vehicle. It was hers, not mine. She's using mine to go to work right now, or I'd have a ride there.
Okay. Well, you didn't show up for the hearing. That's not her fault.
And I paid someone that day. I paid someone that day, and they didn't make it to come and get me, and I walked home from work to make sure I got on the Zoom. I'm sorry, but this is making me mad. I shouldn't even be here.
Well, that's open for discussion. You think you shouldn't be here. They have a different idea about it.
Exactly. Well, when someone jumps in a vehicle, they assume responsibility.
Do you have a legal citation for that? Or is this something you read on the back of a cereal box? You're under the no-fault statute, and it's complicated. And you're in over your head. So you don't show up for your hearing. You don't answer any of their requests for discovery. They sent you information. Everything you've told me, none of it's under oath. This happened, it belonged to somebody. Somebody told me they backed into the car. None of it's under oath. It's just what you claim to be true. So they send you a number of documents for discovery, and you don't answer.
I don't know what that means. Well, I don't know how to do all that. I'm not a good lawyer. I don't have any help. I couldn't hire an attorney because no one would take the case.
Yes, it's a tough situation.
I'm tired of getting ragged on when I'm trying.
This whole situation is all over the place. Like someone tried to mix 5 different court cases into one hearing. There are multiple people involved, and confusion is spreading faster than courtroom whispers. That's exactly why the judge approved an additional discovery, a fancy legal way of saying, we need more info because none of this makes sense. But what does the defendant do? He ignores it completely, doesn't comply, and doesn't even show up for his own court hearing. Genius move, right? Nothing says, I take this seriously, like skipping the one chance to explain your side in front of the person deciding your fate. We're talking about a case involving over $10,000 in damages. That's not pocket damage. You'd think he'd be on top of every email, every notice, every deadline, but nope. Now he's in court acting blindsided with an attitude that could fill the entire courtroom. Yelling at the judge doesn't magically rewind time or fix your case, it just speeds up how fast the gavel drops. The sad part is, this could have been avoided if he'd just done the bare minimum. Show up, cooperate, and maybe, just maybe get a lawyer. Because right now, he's learning what happens when you try to freestyle your way through the legal system. And spoiler, it doesn't end well.
All right, well, all right, you may be trying as hard as you could. Maybe you could spend $50,000 for a lawyer and the no-fault statute still applies. So anyway, you don't respond to the discovery. Everything you're telling me, this isn't how the legal system works. You show up and say, hey, judge, this is all a big mistake. Sorry, here's what really happened. Please dismiss it so I can go home.
They're doing.
Well, they filed legal pleadings.
That should have never happened.
They're prepared to provide testimony regarding the matter. In fact, we took some testimony, or at least some legal representation, on March 31st. So anyway, you don't show up on March 31st. The judgment enters a few days later, and you file a motion to set aside the default on April 14th, which it was in 21 days of the default setting aside. So when you move to set a default aside, there's a certain standard you have to meet. You're supposed to file something called an affidavit of meritorious defense, and you're supposed to show good cause for why you did not appear for the hearing. So in your motion, which you filed on April 14th, I'll just read it. On March 31st, a person who lives with me borrowed my vehicle to look for a job. I totally forgot. Although I called the court around 8:05 and left a voice message as I was going to be late because of no ride. So I walked a couple miles, got a ride. Then when I was home and on Zoom, for some reason, my tablet would not work, the microphone, no matter what I did. I have a meritorious defense for this claim. I, Bradley Roberts, and Keith Ryan, seen Cindy Vandergriff, also who own a 2005 GMC Envoy. Cindy got in the vehicle and started it and then reversed it, which in turn slammed into the plaintiff's parked vehicle, knowing the vehicle had no insurance. Therefore, knowingly take possession of said vehicle, the plaintiff then left the scene. No police were called, and somewhere, someone later gave the plaintiff an old insurance card which had my information on it.
Correct.
Which is different than what you told me at the hearing back in December of 24. So I'm not sure that establishes an affidavit of meritorious defense or a legitimate reason for not coming. I don't have any notes in the file that you called. I don't say that you didn't. The hearing was at 8:30. At any rate, I called the hall and checked around and you weren't here. So having laid the premises out, Ms. Palmer, what's your position here?
Our position is that the defendant has not met the statutory burden in order to set the judgment aside. As the court has indicated, the information he provided as to his failure to appear for a court-ordered hearing, it doesn't rise to the level of good cause, but obviously the court is the gatekeeper of that. But our position is that it does not rise to that level. And then the meritorious defense that was advanced, it is not necessarily consistent with what was originally indicated. And this could have been helped if the defendant had answered the discovery. So right now we're not exactly sure what the defense is. And although I know the courts are somewhat liberal as it relates to advancing a meritorious defense, this is an affidavit. So I couldn't even necessarily use this statement if the court was inclined to set aside the default judgment to impeach him or to have him basically attest to these facts. So he could theoretically change his version after this point too. So we believe that he has not met the statutory requirement to set aside the default judgment at the bare minimum.
This guy really thinks he can just make up his own rules mid-hearing and the court's just gonna go, yeah, that sounds reasonable. That's not confidence, that's delusion with a side of poor legal strategy. The courtroom doesn't run on personal logic, it runs on rules, evidence, and procedure. 3 things this defendant seems allergic to, and honestly, that's the sad part. He might actually have a valid argument somewhere in there, but he's too lost in his own ego to realize how to present it. The legal system isn't built to translate, I'm right because I said so, into a winning case. That's why lawyers exist, not because people can't speak, but because they know how to navigate the system without stepping on every possible legal landmine. Meanwhile, the plaintiff came prepared with an attorney who actually knows what a discovery request is and how to respond to it. That alone puts them 10 steps ahead. The defendant's biggest enemy isn't the opposing party, it's himself. And right now, he's putting on a masterclass in how to turn a winnable case into a courtroom train wreck.
Let me see if I understand. Mr. Roberts, are you contending that this is a completely different vehicle?
No, it's the same vehicle. I gave them her phone number. All they got to do is call her and talk to her. I thought my stuff would be taken care of and thrown out because I shouldn't be here. She said, here's my information, and she lives with me still. It's simple. Contact her and not me. I didn't do it. And they haven't contacted her at all.
All right, but one thing that you, from the beginning, failed to accept is that you're the insurance holder on the vehicle.
Yep, I was. That's what started all this, because someone got my information.
Yes.
So, and I'm not sure if this is the right way to do this, but I was confused in what his defense was here. I thought he was saying it was a vehicle that looked exactly the same as his vehicle that was completely separate. So he's saying that someone got into his vehicle and then drove the vehicle. Is that what this defense is here?
Yes, she got into her 2005 Envoy and yes, drove the vehicle.
That you were the insurance holder on.
Well, used to be at that moment though, and she knew there was no insurance on it because it had lapsed. I wasn't driving it; it was parked.
Your Honor, based on the defendant's statement, and I understand he's not under oath. I misstated maybe in how I responded to the meritorious defense. But if he was the title owner, registrant, or constructive owner of the vehicle, he's still legally responsible for whoever's driving the vehicle if they had permissive use.
Yes, he doesn't understand. But his argument is...
But then when she jumped in it, yeah.
She drove it all the time. You guys were playing fast and loose with the rules. The car was titled in somebody's name, insured in somebody's name, driven by somebody else. There's an accident and the insurance is in your name and now you're outraged. It's your own fault. Then none of this is under oath. I don't know who this car is registered to. I don't know that she's the registered owner. I don't know all this other stuff you told me on December 16th. What you told me in the other letter is different.
Somebody's getting confused because it's simple. Cindy Vandigrift is the owner. I borrowed it because she wasn't driving it. So I insured it. Then I quit driving it and it was parked. Cindy Vandigrift's still the owner. And then Cindy Vandigrift day,
all we know about that is what you're saying here, and you're not under oath. You never filed.
Right. And I'm saying call her and she'll tell you all.
That isn't how it works. They sued
Well, it should have been because I shouldn't be here getting upset. and you shouldn't have to deal with me.
Well, I wish it were true.
Yeah, I know. Okay.
All right.
I'm sorry.
So they send you a bunch of documents to ask you these questions. Who's the car registered to? Show me the title. Who was your insurance carrier? When was it insured? You didn't
How would
answer
I
any
have
of
the title if I don't own it? So I have no idea to fill this stuff out. No idea how to do it.
So all you have to do is show up and say, hey, I don't own this. I don't have any proof that I don't own it, but they're showing that you're the insurance
I did that the first. Wouldn't that be the first meeting we had when I left them her phone number and contact info? It would have been taken care of. If they would have followed through and said, okay, you're not the owner, I'm going to call this number, they would have found out who the owner was legally.
All right. Anything
I can get
further?
on Michigan website and do that.
Your Honor, just in response to defendant's last argument, obviously it's not appropriate to somehow switch the burden to the plaintiff by saying that we were supposed to call and then I guess somehow add her to the lawsuit. We don't have anything definitive to even be able to sue Cindy upon. Maybe if he answered discovery, maybe if he had sworn statements, any of those things. But he just has his versions that he is, advancing that we cannot rely upon.
But I didn't understand.
That we cannot rely upon. So that's why it was critical, and that's why the court opened discovery and allowed us to have discovery for him to answer discovery. That's why it was important. And if he didn't know the answer to a question, could say he didn't know. It's plenty of questions on here. I think 12 interrogatories, 5 requests for admissions, and a request for productions, I believe. So it's quite a few questions on here.
Even though he wasn't behind the wheel when the accident happened, the car was still registered under his name, which legally makes it his problem. That's the thing about ownership. You don't just get to pick and choose when it applies. You let someone else drive your car, you're still on the hook for what happens next. That's why boundaries exist, not just in relationships, but in car loans too. The judge even spelled it out. It's his own fault for giving permission without proper coverage, but now he's backpedaling, claiming the car wasn't really his. That just makes things messier, and since he's not under oath at this point, his statements don't even hold much weight in the record. All of this confusion could have been avoided if he'd just shown up for discovery and clarified ownership from the start, but instead he made himself the legal version of a traffic jam, slowing everything down for everyone else.
First one being his name.
And I didn't understand how to...
Mr. Roberts, you point out a good and valid point. People get involved in a general civil lawsuit. They don't understand the rules. It's complicated. You're not in small claims court, you're in general civil court. And every day this week, including tomorrow, I have multiple people who are driving around with no insurance. And last week on Thursday, I had 7. Probably had 10 last week. I probably have 10 this week. And you point out what happens when you're driving around without insurance. You get into the weeds when you get sued by the other party's insurance company for an accident. And you're in the weeds, all right. You barely filed an answer. You didn't show up for the hearing. You didn't answer any of the interrogatories. And you haven't shown an affidavit of meritorious defense. And I'm not sure we have good cause for why you weren't here. So your motion to set aside the default is denied. Good cause and meritorious defense were not established. Now, you can sue her if you think she's more liable. She doesn't have any money either, and I doubt they're going to get any money out of you. But
when she jumped in it and started it, isn't that taking for the known possession of the vehicle back?
No, it's not. It's not.
Her turn. Okay.
No, it's not. All right, I'm going to send you an order denying your motion. And if you want to appeal that further, I guess you're welcome to do that. But for the reason state, liable for the amount here. You can't even get to court. You have
This
to
is
call
why-
by telephone. And
Yeah, this is
so,
why our country works great. Because Cindy's using my car. I said
well,
that.
sorry about Cindy using his car, but that isn't gonna go very well forward. But for all the reasons I stated, he didn't show up for the hearing. He didn't answer the interrogatories. He didn't show necessarily good cause for why he wasn't here. He didn't file an affidavit of meritorious defense. He said two different things about what actually happened, none of which was under oath. And he just doesn't understand, and he'll be mad no matter what I try to say. So this is another case of it is what it is, and another abject lesson for don't drive around without any insurance on your car. And don't have somebody own it, somebody else insure it, somebody else, nephew or son drive it. When the wheels fall off, it can be very expensive. All right, Ms. Palmer, maybe we'll hear more about that, or maybe we won't, but I've denied his motion and I've signed the order to that effect.
Thank you, Your Honor.
All right, thank you.
You have a great evening.
This case is the perfect example of why everyone needs car insurance and why you should never let anyone borrow your car unless they're covered under it. The auto insurance industry may seem like a hassle, but it's nothing compared to being on the wrong end of a lawsuit. One accident, one bad decision, and you're learning what liable party really means. If you ever find yourself in a mess like this, get a lawyer early and communicate. Don't ghost the court system like it's an ex. This guy's mistake wasn't just what he said in court, it's everything he didn't do before walking in. Thinking you can talk your way out of a legal mess never works. The system runs on paperwork and proof, not vibes. Still, part of me wonders if he genuinely didn't understand how serious it all was, or if he just thought charm could beat law. Either way, it didn't. Do you agree with the judge's choice to deny his motion, or do you think he deserved another shot? Let me know down in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.